All right, we have two cases on our docket today. We'll take them in the order they appear, and after the first case, we're going to take a short break to reconstitute the panel. Our first case is Sims and others versus the state of Florida. Mr. Prenti, you ready to proceed?
Yes, Your Honor. Thank you. May it please the court, Gary Leigh Prenti on behalf of the appellants, Leah Sims and Terri Lee Jones, who are present in the courtroom today. They were the plaintiffs below in a case for declaratory judgment where they were seeking to have a decision rendered to interpret their rights under the interplay of several statutes and the collective bargaining agreement that applies to attorneys that work for the state. And in this case, these plaintiffs hold the position of full-time arbitrators with the Department of Business Professional Regulations Division of Condominiums, and were specifically, this is a job that was created by the legislature to deal with basically the South Florida expanse of condominiums created a lot of civil litigation between parties, and they wanted to keep that from clogging the courts down there, so the legislature set up a scheme to create full-time arbitrators. Not part-time arbitrators, not occasional arbitrators, not attorneys who on case-to-case basis can be designated to act as arbitrators.
Well, let me ask you a question. Your complaint sought a declaratory judgment. It did not include any allegations that the agencies breached the collective bargaining agreement. In fact, as I read it, it didn't even mention the collective bargaining agreement. So how would we get this covenant of fair dealing that seemed to generate a lot of discussion at the trial court in the parties' briefs? How is that even pertinent to our analysis here?
Well, that's what the DMS relied on in making their decision, was under the collective bargaining agreement, we have this right to do this. And once it doesn't become breached, I guess that is a point that, was it a breach of the collective bargaining agreement? If so, correct, we didn't plead that. So I'm kind of, but that's what they relied on in making their decision, is the collective bargaining agreement, and their interpretation of it gives them final unlimited say in how we get here. And our contention is they acted arbitrary under the collective bargaining agreement.
Well, let me ask you another question on that. The terms of the collective bargaining agreement makes DMS's decision final and binding on both parties. So how does this even get into the court system?
Well, if they do something that is arbitrary under contract law, then there must be some way to challenge it. For example, if they said that these people, you're not even attorneys, you are engineers, that would clearly be in breach of the agreement, the contract, collective bargaining agreement, because how could you decide that? What facts did you use?
Your position is that it's a breach of contract, so certainly you were able to bring a breach of contract claim, correct?
Yes.
There was nothing that precluded you from doing that.
That's correct, Your Honor.
Talk to me about the statute. This pool of arbitrators, it seems as I read the statute that there may be three different sort of pools of people that could act as arbitrators. Those who are full-time attorneys that act as arbitrators and are employed. Those who aren't employed, so I guess they're sort of contract type arbitrators. And then there are full-time arbitrators that must be members in good standing of the Florida Bar. Are there three pools, or am I reading that correctly?
Well, I believe that is the most recent statute that has because there was a provision put in there to allow them to contract out. Whereas when the original statute that we brought this under was passed, they were all simply full-time employees of the Division of Condominiums. And that's a key thing, is they don't do any of the things that attorneys for DBPR do. Same as at Department of Management Services. They have assistant general counsels. They do work on behalf of their agency. They do the same thing that lawyers who work for DBPR do, but none of those people would be doing what these arbitrators are doing exclusively. That's the key, is that they do this exclusively. By statute, they cannot say, come in here or go appear in DOA and represent the Department of Business and Professional Life, taking somebody's license away. Say, well, you're not doing anything this week, go over there and represent them. Someone else can do that. Solicitor General's office, you could say, we're going to send you down to assist in a trial because we want to make sure the appellate errors and things that we want to bring on appeal are preserved. You're going to go down there. Person can't say, or there's no statute that would preclude the AG, the Attorney General's office, from saying, I'm ordering the Solicitor General's office to send staff down there to work on a trial in a support capacity, or I suppose even to do the trial themselves if they're familiar. Whereas here, they would be stopped from doing that. That's the whole point of that, is they would be stopped and under statute cannot do it. Now,
Let me ask you another question about the department. Looked like it gave two reasons for their final decision. One of them is a statutory interpretation, because the statute says that they shall be full-time attorneys that act as arbitrators. And the other reason they gave is that really there's no financial impact to the plaintiffs here, whatever their classification is. Do I understand that first rationale in the sense that these current plaintiffs, their salaries fall within the range of hearing officers already, so even if they were reclassified, their salary wouldn't change? Is that the point they're making there?
that's the point they're trying to make, but that point is incorrect. There is a pay grade that applies within the pay band. And so they would have to be something above per hearing officer's minimum, which is $63,000, which is more than they make. The average PERC
What
officer,
would require DBPR to use the same pay scale as PERC?
in 110, it says that those employees who are select exempt, which these full-time arbitrators are, they serve at the will and can be fired at any time. PERC hearing officers have career service protection. So if you're in the same pay grade and you have career service protection, which protects you from, gives you that judicial independence thing, whereas these people only represent private parties, so there's not this concern that, well, you're going to rule in the state's favor because the state pays your salary. But they have to be paid more. When they created the Select Exempt Act that created select exempt employees, they said they have to be paid more for people in career service, because we're taking away your career service protection. This is what you get. You get paid more. You get more benefits because of that. And that would apply to them. So they would then be different from PERC hearing officers and subject to being paid more than PERC hearing officers, because we're both adjudicators in the same pay band, but we don't have career service protection and you do, so you have to pay us more. And it also says that when in deciding the classification, money is no object. You either have to say, we're not going to make you do the duties that put you in that other pay grade, so you can't complain about it anymore. But here you can't do that because it's designated by statute that this is what you do.
So your response on that point is that the DMS was factually wrong about it not having any financial impact on these plaintiffs, number one, and number two, that whether it did or it didn't has no bearing on whether they are properly classified.
Yes.
Okay.
Is there any more questions? Because I forgot to tell you I was going to save 5 minutes, but
All right.
I think as I read this, that's where we're almost there. But anyway, so that's our position, is that You cannot put someone who doesn't do any of the things of an attorney under DMS's own system of classification. Here's what state attorney, government employee attorneys do for agencies, a list of things. Here's what the adjudicators do, a list of duties. There's only one interplay in there, and that's they both do legal research, which it's good to know that our adjudicators are doing legal research. But it's the only connection between the two. There's no other connection. They don't represent people. They don't prosecute people. They don't give advisory opinions to their boss. They hear cases, and they have binding authority in many of those cases when they do hear them. And that is what makes them adjudicators and not attorneys. Simply because they seized upon the phrase that they have to be attorneys. Well, PERC hearing officers have to be attorneys. You know, administrative law judges have to be attorneys. To say somebody must be a member of the bar to act as a full-time arbitrator doesn't mean you lost your status as a full-time arbitrator. That was just to get in the door. Anyway, I'm going to take my time.
All right, thank you, counsel.
Good morning. May it please the court. My name is Ross Marshman, and I represent the appellee, the Department of Business and Professional Regulation. Mr. McVeigh, on behalf of DMS, is sitting at the table with me. I would like to take approximately 7 minutes of our total time to address 2 points, while Mr. McVeigh will use the remainder to address the third. This case really comes down to 3 things: the language of the Condominium Act, the collective bargaining agreement, and what's not in the record and why that matters for a motion for summary judgment. DBPR and DMS in this case correctly decided that the appellants were correctly classified as attorneys serving as arbitrators on behalf of DBPR's Division of Condominiums, Timeshares, and Mobile Homes. The language of the Condominium Act, Chapter 718, states at the time the complaint was filed in 2016 that the division was to shall employ full-time attorneys to serve as arbitrators.
Now, did their duty?
Go ahead.
Did their duties in this case, they're on the ground, duties in this case match the occupational, doesn't match the occupational profile for an attorney?
Yes, Judge. On page 105 to 106 of the record, DBPR has produced in its response and its motion for summary judgment the position description that it maintains for the senior attorney role of an arbitrator. And that actually copied the exact language from DBPR's occupation profile for lawyer, which is found on page 57 to 61 of the record. So again, there is overlap between the occupation profile and the position description that DBPR maintains.
So your position isn't that those things can say different things? Your position is that they must be consistent. Their duties must be consistent with the occupational profile.
Yes, Judge. Under Chapter 110, the department is required to maintain accurate position descriptions for all of its employees, and we maintain that it is an accurate description of the duties of a senior attorney serving as an arbitrator.
Let me ask you this. You refer to the statutory language that says the division shall hire full-time attorneys to do arbitration. To me, that is almost the same as what the DOA statute says. It's not worded exactly the same, but the two statutes essentially say you hire attorneys to do the work of an adjudicator. I'm having trouble understanding. I mean, DOA statute says the division shall employ administrative law judges to conduct hearings. Any person employed as an administrative law judge must be a member in good standing of the Florida Bar. I mean, it sounds like your argument hinges on the fact that the DOA statute doesn't say the division shall employ attorneys to serve as administrative law judges. I mean, if that's how the DOA statute was worded, your argument would be the DOA judges are lawyers, not adjudicators, right?
Your Honor is correct that there is a distinction between the Administrative Procedures Act and the Condominium Act. However, DBPR maintains that that is a distinction that matters based on the language that was used. As Your Honor pointed out, in the Administrative Procedures Act in Chapter 120, Section 65, the legislature states that the Division of Administrative Hearings shall employ administrative law judges. And in the Condominium Act, the Division of Condominiums is required to employ attorneys as arbitrators.
Well, how is that materially different, I guess, is what I'm struggling with. The point of both statutes, it tells you what kind of people you hire, attorneys, and it tells you what role they are to perform, administrative law judge, arbitrators. The fact that one statute puts attorneys first and the other statute puts it later, I guess I'm not seeing a material difference in the statutory language versus what the people do.
So it's DBPR's position that a arbitrator, which is a separate occupation profile under DMS's broadband system, is one that resolves disputes between parties. They're not tasked with making determinations, and an arbitrator's decision, while it is final, it is not final agency action, and unless the parties to the arbitration agree beforehand, the parties can seek a trial de novo in circuit court. Unlike with an administrative law judge, they are tasked with adjudicating the claims and either doing a recommended order to the agency as a fact finder.
Which is not final agency action.
Correct, in that situation. However, in a rule challenge, perhaps that would be considered final agency action. So DBPR maintains that while the language may be similar on its face, the roles of an arbitrator compared to an administrative law judge or a hearing officer are distinct.
But doesn't 110 talk about, the duties and responsibilities? I mean, it says it in a couple of different places, if I remember. Even the CBA talks about, that's what you focus on. You don't focus on what kind of person the legislature's told you to hire. You focus on what that person is supposed to be doing. Do you disagree with that?
I don't disagree, Your Honor. I believe that it's taken in conjunction with one another. I believe the legislature was specific in the Condominium Act by stating attorneys as arbitrators, and perhaps it was less specific in Chapter 120 when it said administrative law judges. Of course, both have to be attorneys. However, I still think there's a distinction between their roles. And
Mr. Prenti argued that the hearing officers here should have at least a higher salary than the PERC officers. And are there any other hearing officers within state government who are also SES who are paid less?
Yes, Your Honor. Hearing officers in the Department of Economic Opportunity make a much lower amount of money. They're in a completely lower pay band. I believe they're in pay band 17, if I'm not mistaken. And they were only recently required to be attorneys, so they make significantly less than arbitrators in the Division of Condos.
Are there hearing officers within the same pay band as these arbitrators who are paid less?
I'm not sure, Your Honor. I know that DBPR does not employ any other arbitrators within the same pay band as these, because these are the only arbitrators that DBPR employs. I'm not sure of any other agencies that employ arbitrators in the same way that DBPR does. Just briefly touching on the language of the collective bargaining agreement, I believe the court has already discussed it somewhat in the beginning, so I won't belabor the point. However, Article 11, Section 1B of the collective bargaining agreement was, on its express terms, made DMS the final and binding word on this dispute. There's nothing that the appellants can point to in this case in the collective bargaining agreement that gave them the right to go to circuit court to challenge the decision of DMS in this case.
Could they have brought a breach of contract action?
It's possible that they could have brought a breach of contract action. However, in this case, they did not. While that was discussed during the appellant's portion of oral argument, it's important to remember that this was a complaint for declaratory and injunctive relief. They did not raise any sort of arbitrary or capricious conduct until the motion for summary judgment. So there's nothing in the verified complaint that discusses the actual breach of a contract claim in this case. And I believe Mr. McVeigh will discuss in further detail how there is no record support anyway for the argument that DBPR or DMS acted in a way that was arbitrary or capricious.
It looked to me, when you read the DBPR letters and you read the DMS letters, it was almost as if nobody was aware of this collective bargaining agreement at that stage of the proceeding, because you would expect in a letter that is taking the action the CBA requires each of the agencies to take, they would have at least referenced it. I mean, is that a unreasonable interpretation of the record?
Just to clarify, Judge, when you state that the parties didn't know exactly the impact of the collective bargaining agreement, are you referring to the state agencies or the
Yeah,
arbitrators?
I'm looking at Ms. Peek's letter, and, I mean, unless I misread it, it nowhere even mentions the collective bargaining agreement. I mean, did I misread that?
You're not misreading that letter, Judge. However, in the request that the appellant sent to DMS, they made it explicitly pursuant to Article 11, Section 1B of the collective bargaining agreement.
Okay.
And I believe I am out of my allotted time, so I would ask the court to affirm the trial court's order in this case. Thank you.
May it please the court. Good morning. My name is Brad McVeigh, and I represent DMS in this matter. And I'd like to start, I guess, where the trial court ended, and that is with the granting of summary judgment. In this case, there were no facts in dispute. I mean, the record is clear, the facts are clear, and it's a straightforward contract case, which is how the trial court, in my review, treated the case.
So your view is that the parties tried it by consent as a breach of contract action?
Well, no, Your Honor. That's not what I'm saying. The complaint in itself is couched in a deck action. What they argue, though, is really better suited for a breach of contract. They allege through a motion or a response to summary judgment bad faith, which is not alleged in the complaint, or implied duty of bad faith. And so what the trial court, I think, did is look at the record, and there, with no facts being in dispute, correctly under the collective bargaining agreement, the provision 11B, which is what Mr. Marshman just talked about, and I think that's 52 in the record, is a letter was sent to DMS in order to review the decision that was made by DBPR.
And the basis for the decision, best I can tell, in Ms. Peek's letter was twofold. One, to paraphrase, why do y'all care about this? Because you're not going to get any more money, number one. And number two, the statute says they have to hire attorneys. I mean, there was no analysis of, at least on the face of the letter, on what they're actually doing. Was there?
I agree with you, Your Honor. There's no analysis on the letter. But there is, if you look at the underlying, if you actually look at the record, and I'll reference the record number, and what they're tasked to do in this analysis, I agree the letter is unclear. I mean, the letter, as it's stated, it looks at 718 and basically says, it says attorneys, and that's the best reason for it. It doesn't say it's the only reason. I think that's the key here.
Is that really even a good reason?
I don't know that it is a good reason, but in the letter it does admittedly say it's a compelling reason. I don't know that I agree with that, but the key is it doesn't say it's the only reason. And I think if you look at the collective bargaining language, what DMS was tasked with doing, if you look at A first and then go to B, A, it was when an employee alleges that he's being regularly required to perform duties which are not included in the position description that is filled by the employee. The position of this description is a document that was also in the record at 110, and it just describes exactly what 718 says. The position description has never changed, and therefore the position that they took upon entering employment as an attorney is the same as what's described in the position description that's on file.
But in that same sentence of the CBA, it also says the employee alleges that the duties assigned are not included in the occupational profile. So it's not limited to the position description.
Correct, Your Honor. And I appreciate you getting to that point. And that's the next point I was going to make. In the description in the occupation profile at 57 in the record, is work representing the state of Florida in criminal or civil litigation and administrative or other legal proceedings. That's what they do in essence. That's what the arbitrators do. They are representing the state of Florida. There's a private entity as a condo association. There's a private entity as a condo owner. But they are employed by the state of Florida, and they represent the state of Florida in this.
Explain to me how somebody that's deciding a dispute between two parties is representing the state of Florida. I mean, I know they're employed by the state
Yes,
of
sir.
Florida.
And that's what I mean. They're hired, they're employed by the state of Florida. To me, the distinction, there isn't really a distinction. They're employed, they're representing the state. I don't, in the sense that they're going to court and representing one side of the dispute, that's not true. But they are.
Isn't that what that, I mean, we're representing the state of Florida. We got a flag
Sure.
behind us, so we're representing the state of Florida. But I don't think anybody would suggest that we are, I mean, as lawyers, we know what the word represent means. I mean, we're not representing the state of Florida the same way assistant state attorneys do.
No, I agree, and it's that I agree with. But in order to continue, I mean, you have to look at the entire description of this, and then go in and in this occupation profile, Your Honor, record 57 and 58, there are a number of examples too, many of which fit what these folks do. So the determination, like you said, Judge Rowe, is twofold. You look at the position description, you look at the occupation profile, and both of those items, when you look at them, this is something that they do, the arbitrators do, both of these things, and they match. So DMS's evaluation was correct in this sense, and I think you should affirm the trial court. Thank you.
All right, thank you, Counsel.
One, I would think that there are some points raised in both these arguments about DEO, hearing officer, or they're called referees. The ones I've dealt with have never been lawyers, but we have hearing officers throughout the state system that aren't lawyers, and I imagine they're in pretty low pay grades, traffic review things, and at Department of Highway Safety. But getting back to the main game is, we sought injunctive relief saying that we have been misclassified. Now, if you want to characterize that as a breach of contract of the collective bargaining agreement, I don't know if that's necessary to say that. We were misclassified. How we came to be misclassified does it matter? Get us class, do the right thing. It's clear that if you don't consider what these people do, in deciding whether something is arbitrary, you look at what do? What do you say they do, and what do they do? Well, they say they do totally different things than what they do. To say that they perform the functions of attorneys representing the state when they are adjudicating disputes between private parties that the state has nothing to do with, other than we will provide you a forum to litigate your dispute, is not only a stretch, there's no basis for saying that. And so that's where this arbitrariness comes in, is they grabbed onto a phrase, DMS grabbed onto a phrase that was placed in their record by the letter from DBPR that, well, because you're attorneys, this is the way it is. And I think the court understands that point. And so what is the relief? What do we want here, I think, is what it seems like. That's, whether if we win, obviously on appeal, this court or this case has to go back to the trial judge to do things. And it seems like there might be a better, if it goes back to the trial court, one thing the trial court would have to probably do is hear a testimony or take evidence on what the pay raise or pay grade should actually, we say it's one thing, But to actually determine that, how much it should be, what, because, only the trial court's going to take action for writing up an injunction and doing what the injunction says, so it's going to go back there. And that's what we wanted to do. We wanted to go back there.
Does the record tell us how many of these arbitrators there are? I know we've got 4 or 5 plaintiffs here. Is that the whole group of them?
No, there were the 4 female arbitrators brought this lawsuit. The 4 men arbitrators didn't want to get involved. And those 2 I think there's 6 left. That was never, didn't really matter whether there were 6 or 50. I mean, it's what they do and what they're classified as. Because it just as a final point, I want to point out that, the collective bargaining contract only applies here, agreement only applies here because they were classified from the very beginning when this was created by DBPR, and nobody challenged it, as attorneys. And therefore they fall under the CBA. Had they been correctly classified from the get-go, and they could have challenged this a long time ago, they would be outside the collective bargaining agreement because they are not attorneys who represent the state. That contract only applies to attorneys who represent the state, and they do not represent the state.
But that argument isn't really in this case. I mean, you haven't argued that the collective bargaining agreement doesn't apply here, have you?
Well, only because it only would apply if they were correctly. What I guess I'm saying is it shouldn't have applied, but they should have been classified correctly in the first place, and they weren't. So they classified them out of or into the CBA instead of classifying them out of the CBA.
Very good. All right, your time has expired. Thank you both for your arguments. We will be in recess for 5 to 10 minutes to reconstitute the panel.
All rise.